Dear beloved Creator within and without, we gather to acknowledge our unity and our collective purpose. We know from deep within that it is up to each of us to hold a moral and ethical line when seeing it crossed. We ask for your protection, Creator, from all hostility or roadblocks, so that our humankind can live in the abundance and the compassionate world you created. So now we are putting on the armor of God. It is you, it is me, it is us. We are the ones who are taking this on, and together, because it is our calling to put a halt, a full stop, and then a correction to the harm that is coming at us, and especially at our children. They are the innocent ones. As their protectors, we cannot be naive or uninformed, and so we gather our spirits in your name, Creator of all that is. And so it is.
Thank you, Charlie.
My pleasure.
My name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I've got a few words I'd like to read. There is a shibboleth among the people of the words. Quote, your provenance unique on earth from the unanimous declaration of the 13 United States of America. Read the opening paragraphs again. When, in the course of human events, it becomes necessary for one people to, one, dissolve the political bonds which have connected them with another, and two, to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitles them. A decent respect to the opinions of mankind requires that they should, three, declare the cause which impel them to a separate, to a separation, 1776. Then 1777, Confederation and Perpetual Unions Articles styled the United States of America's apostrophe S Constitution 1859 prior to 1861. Their United States of Washington District of Columbia Inc. in some form is the de facto. We are sovereign. See http://www.1215.org for the Bouvier Dictionary. All of us are sovereigns, only us and kings and other governments. There is also de facto and de jure, page 416, Black 6th edition, illegal or illegitimate. They changed the definitions in Black's 11th. So, only you can obtain and hold the mindset. No one can do it for you. You cannot do it alone. The remedy is the shibboleth. Among all of us, with the goal of returning to a constitutional Republican form of government this year, 2024. A working solution is to follow the prompts, assemble as in Amendment 1. That's from the Bill of Rights. Form a social compact, as in Article 1, Section 1 of Oregon's Constitution. Petition for redress of grievance. That's also the First Amendment. And form a civilian common law court of record, implement ex parte Milligan and nullify martial law, Lieber Code, and FEMA. Form a jury pool with men and women with their bona fides in order. Call a grand jury and one appears and finds presentments and true bills. Call in Article 3, Amendment 7. One Supreme Court claiming original jurisdiction found in a common law jury. As the value is over $20, there are no judges involved, and the verdict has no appeal in fact. Our Oregon Statewide Jural Assembly took all of those steps and more. Our Social Compact, Article 1, Section 1, is the provisional government on Oregon as of November 2022 and acquiesced to by the U.S. DOJ, U.S. Marshal Services, the FBI, the U.S. Marine Corps, the state of Oregon, the Salem oligarchy of executive, legislative, and judiciary, 36 sheriffs, 38 prosecutors, all signed, sealed, stamped, witnessed with proof of service, and published at www.orsja.org. Next, find unfettered service of counsel at www.orsja.org. Enter their court with a claim of cognizance. Notice, claim of cognizance. An intervention by a third party, Charlie White, is one of the people who are cognizant of the facts contained in a suit claiming a jurisdiction unanimously agreed to in Edict 2 of the 1776 Declaration, definition of civilian, of the people on the land or water or in the air, not a fictitious entity. There is a matter of jurisdiction. Tentere placida does not oust the other court of its jurisdiction, but only creates a concurrent one. The sovereign Oregonian, Ronald Charles Vroman, the man, juris summi imperi, giving no jurisdiction, has rightful jurisdiction of the cause, which the persons in the de facto jurisdiction have commenced out of the sovereign Oregonian's de jure jurisdiction. This is between courts, not between any man and an Article 1 court or an Article 7 amended or original court or a municipal court, appellate, or Supreme Court in, on, for, by state of Oregon, aka a subdivision of the United States of Washington District of Columbia, Inc. in some form. There are two additional types of claims of cognizance for the safety of the de jure people against a de facto for-profit court. The people are guaranteed an Article 3, Amendment 7 civilian common law court for a trial. We can provide that court if they cannot find their authority among their bona fides. And a notice and demand and caveat to will. A demand that will be produced and probated in open court, an attack on the validity of alleged will, fulfilling the role of formal complaint as requested with the bill of particulars. And I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. And then he jumps out of the car. And he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.